Medical malpractice is professional negligence by act or omission by a healthcare provider in which the treatment provided falls below the accepted standard of practice in the medical community and causes injury or death to the patient, with most cases involving medical error. Standards and regulations for medical malpractice vary by country and jurisdiction. Within countries, medical professionals may obtain professional liability insurances to offset the risk and costs of lawsuits based on medical malpractice. In addition, other preventable measures are available and will be discussed shortly. The tort of negligence serves as the subject of malpractice cases. At trial, both parties will usually present experts to testify as to the standard of care required and other technical issues in order to prove or disprove this negligence. A 2011 study in the New England Journal of Medicine reported that 75% of physicians in low-risk specialties and virtually 100% of physicians in high-risk specialties could expect to face a malpractice claim during their careers. Most 73% of settled malpractice claims involve medical error. A medical error is a preventable adverse effect of care, whether or not it is evident or harmful to the patient. This might include an inaccurate or incomplete diagnosis or treatment of a disease, injury, syndrome, behavior, infection, or other ailment. The total number of injuries and deaths due to errors were greater for outpatient settings, however, and 1/3 of all claims were the result of misdiagnosis. Doctors' groups, patients, and insurance companies have criticized medical malpractice litigation as expensive, adversarial, unpredictable, and inefficient. These critics assert that these rate increases are causing doctors to go out of business or move to states with more favorable tort systems. Many doctors even have been pushing for reforms such as specialized medical malpractice courts. In regards to a doctor or medical professional protecting oneself from becoming victim of malpractice, medical malpractice insurance is a must-have. Medical malpractice insurance insures against claims of medical negligence. Most policies also cover your conduct as a member of a peer review panel. Indiana specifically is a very attractive place for doctors to practice due to our unique Malpractice Act. Indiana was the first state to pass medical malpractice reform legislation in 1975. The act provides a doctor-friendly insurance policy, which in turn, more physicians can afford to practice in Indiana and patients have access to the care they need. Physicians are not required by Indiana law to maintain any malpractice insurance. However, as a practical matter, employers, hospitals, and payers usually require it. Additionally, in order to qualify for the protections built into the Indiana's law, like cap liability, physicians must purchase commercial insurance. Often, a good doctor-to-patient relationship can prevent lawsuits, even if the result of care didn't go the patient's way. Preventable duties performed by medical professionals to hopefully prevent malpractice lawsuits and therefore eliminate any need to use insurance altogether is as follows. Faulty communication. Honest and open communication is the best approach. Listening carefully, offering clear answers and instructions, addressing complaints, setting realistic expectations, including family members, and documenting thoroughly are all good techniques to improve communication and avoid risk exposure. A bad outcome is not always synonymous with malpractice. However, a bad outcome and poor communication are usually the driving force when a patient or family considers litigation. 2. Lack of consent. It's essential to verbally communicate the risks before a procedure, not after, and to include this information in a written consent form that the patient signs. The patient must receive a proper explanation of the form's purpose that clearly spells out the risks inherent in the procedure. Physicians also need to be aware of new and revised developments in their areas of practice and specialties. 3. Failure to follow up on tests. If tests are given, professionals must follow up with a patient, informing them of their status. 4. Avoidance. Compassionate gestures count. If a hospitalized patient has a bad outcome, some physicians may avoid making rounds in the presence of relatives. Don't be afraid to face them. It's important to let them know you understand how they feel. Make eye contact with whomever you're addressing and put a comforting hand on the individual's arm. 5. Procedural confusion. In practices with multiple physicians, occasionally, physicians' procedures will vary. Rarely, but occasionally, these procedures will be mixed up with employees, doctors, etc. To avoid this, most clinics only allow one common procedure. All these things can help prevent medical malpractice by improving that patient trust in the doctor. If the patient feels like everything went as planned and if they felt that they were informed, they are unlikely to file a litigation case against a doctor. How in-depth do doctors communicate to patients prior to surgery on the procedure and possible risks?
Well, first of all, a surgeon will meet with the patient in the physician's office days or weeks before the surgery, and he will go over everything about the surgery, what it's going to entail, what the risks involved are, what complications could possibly arise. They'll talk about the recovery time after the surgery. And after all that is discussed, the surgeon will have the patient sign a physician's consent in the office. That's something that he'll keep on record for himself, that the patient has been informed of these things. Then once the patient is at the facility where they're going to have the surgery, they sign another consent there for the surgery center.
What goes on inside the operating room during operation to protect oneself from any form of malpractice?
Well, there's several things that are implemented during this time that a patient is in the operating room. The first one is, before the patient is ever asleep, their name is read out loud. Their wristband is checked to make sure they have the proper patient, to also with the proper surgeon's name. The physician or the anesthesiologist will ask the patient multiple times which surgery site, if it's a limb especially, if it's an arm or a leg, which site is being operated on. We implement things like an allergy band. So if the patient is allergic to a medication, they wear a bright orange band on their arm, indicating that. That's just another way to prevent accidents from occurring that way. Another area that we prevent, accidents is by charting everything that we do. Everything's written down on a written document in the OR that is done for that patient during that surgery. That way we have a permanent record of it.
During medical malpractice claims, what acts of defense does the outpatient center take?
Well, first of all, the outpatient center would have a lawyer that represents them. He would review the records. That's probably his main thing to look at, is what went on during that surgery or that time that patient was in the facility. And so everything is recorded, from medications given to vital signs to supplies that were used for the surgery, just the way the patient was positioned during surgery. Everything is documented. So they'll review all that. Sometimes they'll have to interview or talk with staff that were in on the surgery. And I've been involved in that before, where I had to sit with a lawyer and discuss what we did for a patient during a surgery, along with the chart, just so that he was very well informed, so that when he went to the case, I guess you'd say, he was well informed on what we did.
Cindy, thank you for your time.
Thank you.